You have probably heard the phrase the rule of law already. It's something that frequently appears in court judgments, textbooks, and public debate. The rule of law is one of the most cherished political ideals in the world, but it's also a complex and contested concept. I'm going to talk to you about three aspects of the rule of law. The first is, what is the rule of law? And relatedly, what is its purpose or its value? The second thing is, what kind of concept is the rule of law? Is it a political ideal or a standard of legal validity? And the third thing I'm going to talk about is the place of the rule of law in the Australian legal system. The rule of law is central to our understanding of public law, and it's something that we're going to revisit throughout the course of this unit. At the most basic level, the rule of law is what distinguishes a healthy, well-functioning legal system from a despotic or tyrannical regime, or anarchy. It's a system in which government power is conferred and limited by law. In a system that has the rule of law, people can't do whatever they want, however they want to do it. They can only do what they are legally authorised to do, and that applies equally to people who hold public office. That means that no one in the legal system is above the law. Everyone is subject to the law. And so when we have those things, we can say we live in a system in which law rules, not people. Those are all really important ideas, but they are also fairly abstract and we need more detail. The first question is, what specific principles and practices do we need to put in place to be sure that everyone is conforming to the law and bound by it? The second is, what is the character of the law to which everyone must be bound? The rule of law has to mean something more than the requirement that everything be legally authorised by some recognisable source of law. Let me give you an example of what I mean. Imagine you have a statute that says, the minister can do whatever she likes. In that kind of circumstance, then whatever the minister chooses to do, no matter how arbitrary or unreasonable it is, her actions are legally authorised. Strictly speaking, she's subject to the law. But that doesn't look very much like the kind of regimes that the rule of law is supposed to distinguish us from, in which those who hold public office can really do whatever they like. The significance of this is that the rule of law also seems to speak to the character of the law, or the legal powers that those who hold government positions can exercise. Legal theorists have discussed this topic at length and come up with various different ways of defining the rule of law in more detail. Several of those theories are set out in your readings for this week, and I want to draw your attention to some of the main points to take out of those readings. The first thing is that different theories of the rule of law can be broadly categorised as either thin or formal, or thick or substantive. Thin or formal conceptions of the rule of law typically focus on the procedures by which law is made and carried out and enforced, rather than its substantive character. Thick or substantive conceptions of the rule of law tend to have a more broader focus on the quality of the law itself and the quality of the legal system. They are often concerned with the justice or fairness of the laws that make up the legal system. Let me give you an example of this point of difference. Joseph Raz, one of the theorists mentioned in the book, defined the rule of law as having two aspects. First, that people should be ruled by the law and obey it. And second, that the law should be such that people will be able to be guided by the law. Raz explains that if the law is to be obeyed, it must be capable of guiding the behaviour of its subjects. It must be such that people can find out what the law is and act on it. Consequently, Raz focuses on requirements like the clarity, predictability, accessibility, and prospectivity of the law. He insists that if the law is not clear, predictable, open, and prospective, then people cannot be guided by the law or bound by it in the end. Prospectivity is a really important issue related to the rule of law. What we mean by prospectivity is that laws only have legal effect after the point in time in which they are made. If a law is made that has a legal effect before the law was made, then people are effectively bound by laws that were unknown and unknowable at the time they acted, because the law didn't exist at that point in time. Raz goes on to explain that the rule of law is a political ideal, which a system may lack or possess to a greater or lesser degree. We'll come back to talk about that more in a moment. Importantly, he also says that the rule of law is not concerned with justice or fairness. Let me read this quote to you, which encapsulates Raz's view. The rule of law is just one of the virtues which a legal system may possess and by which it is to be judged. It is not to be confused with democracy, justice, equality before the law or otherwise, human rights of any kind, or respect for persons, or for the dignity of man. A non-democratic legal system based on the denial of human rights, extensive poverty, racial segregation, sexual inequalities, and religious persecution may in principle conform to the requirements of the rule of law. This does not mean that it will be better than other legal systems. It will be an immeasurably worse legal system, but it will excel in one respect, its conformity to the rule of law. So this clearly portrays the rule of law as a very formal concept that is solely concerned with ensuring that the law is capable of guiding human conduct. We can contrast that quite clearly with a different theory of the rule of law put by Lord Bingham, a former UK judge. He explains that while one can recognise the logical force of Professor Raz's contention, I, meaning Bingham, would roundly reject it in favour of a thick definition of the rule of law, embracing the protection of human rights within its scope. A state which savagely represses or persecutes sections of its people cannot, in my view, be regarded as observing the rule of law. Even if the transport of the persecuted minority to the concentration camp, or the compulsory exposure of female children on the mountainside, is the subject of detailed laws duly enacted and scrupulously observed. So to hold would, I think, be to strip the rule of law of much of its virtue. And you can see here that Bingham is defining the rule of law in a thicker and more substantive sense, which is designed to capture something more about how a healthy legal system differs from one under the leadership of a dictator or despot. The second aspect of the rule of law that I'm going to talk to you about is what kind of concept is the rule of law? Is it a political ideal, a goal or an aspiration that we expect government actors to strive towards? Or is it actually a legal rule, a standard of legal validity, in which case government action that did not conform to the rule of law would be legally invalid? This is also something upon which legal theorists disagree. Some argue that the rule of law is just a political ideal, an external yardstick against which government action can be judged. And you can see that's quite similar to the idea of the rule of law presented by Joseph Raz that I was just talking about. Often that view of the rule of law is motivated by the fact that it is so complex and contested a concept. If we say that the purpose of the rule of law is to ensure that the law is clear, predictable, knowable, so that everyone can be guided by the law and ultimately bound by it, then the precise principles and practices that are needed to achieve that are going to vary greatly depending on the legal system in question. Let me give you a really basic example of that. Let's say that the rule of law requires that the law be accessible. That is, people can find out what the law is. Now, if your legal system is very small, governing a very small society, then that can be achieved pretty simply. You can imagine affixing a sign in the village square stating what the law is, and pretty quickly everyone within that community will be able to read that sign and figure out what the law is. That's not going to work in most large, complex modern legal systems. We can't just affix a sign in the village square and expect everyone to figure out what the law is. We need some other system of making the law accessible. That's just a very simple example of the way in which the principles and practices that are needed to attain the rule of law are going to vary depending on the legal system in question. The other complexity, and this is something that Raz also emphasises, is that all of those principles and practices are not necessarily absolute. There are good reasons why, in certain circumstances, they may have to be compromised. We can use the principle of retrospectivity as an example of this. Remember, we said that the rule of law generally requires that laws be prospective, that is, only have legal effect after the date on which they are enacted. But as we'll go on to learn, Australian parliaments can enact retrospective laws. In fact, retrospective laws are not an uncommon feature of our legal system and many other legal systems. There are many legitimate reasons why a government may decide that retrospective law is needed. There have been really high-profile examples of that in our history. Think back to examples such as the retrospective investigation and prosecution of Nazi war criminals. That's an example of retrospective government action, but most people would agree that it was legitimate in those extreme circumstances. The point here is that none of the requirements of the rule of law can be wielded like an absolute rule. They're complex and they require a degree of balancing with other important political goals. For that and other reasons, many people argue that the rule of law is a political ideal, not a standard of legal validity. But other people take a different view. They insist that if the rule of law is so important, it can't be left to the realm of politics. It has to be protected by legal means. It's not enough, some people argue, for a government to strive towards achieving the rule of law. It's too important for that because they may well fall short. Or worse, simply decide to throw off the shackles of the rule of law because they find them inconvenient. More theoretically, it's sometimes argued that the requirements of the rule of law are intrinsic to our understanding of law itself, and so no true government can ever rule contrary to its requirements. These are pretty complex theoretical debates that we don't need to delve too far into here. What I'd like to turn to instead is a discussion of the place of the rule of law in the Australian legal system. The starting point here is a really famous case called Australian Communist Party and the Commonwealth. This is a case we're going to come back to look at later in the course. This case concerned legislation enacted by the Federal Parliament in the midst of the Cold War during hysteria about the spread of communism. There was widespread fear that the communist ideology was spreading throughout the world and that the communists would soon attempt to overthrow the capitalist system of government. Public opinion polls taken during this time show that there was widespread public support for banning the Australian Communist Party. So that's exactly what the Federal Parliament did. They enacted sweeping legislation that outlawed the Australian Communist Party, confiscated all its property, and made it a criminal offence to be a member of the party or to in any way support its teachings. This legislation was challenged before the High Court of Australia. Ultimately, the court found that the legislation was constitutionally invalid and struck it down. In the course of his judgment in the case, Justice Dixon said that the rule of law forms an assumption of the Australian Constitution. If you have a flick through the Australian Constitution, you don't find the words the rule of law. They're not in there. But we've already learned, and are going to learn in further detail in the rest of this course, that the Australian legal system is one in which all the branches of government at state and federal level are bound by law. At the federal level, the primary source of that law is the Constitution itself, which operates as a higher law. In this case, the High Court said that it was its responsibility to review the legislation that Parliament had enacted and check whether Parliament had conformed with the limits on its power imposed by that higher law. In other words, whether the Communist Party Dissolution Act conformed to the Constitution. And ultimately, the court found that it did not. This demonstrates that the rule of law is a fundamental feature of our Australian legal system in two ways. The first is that Parliament is not above the law. it's bound by the law found in the Constitution, which operates as a superior source of legal principle. Even though this was a time of perceived national emergency, even though the government insisted that this legislation was vitally necessary to national security, and even though it appeared to enjoy widespread public support, the legislation in question was invalid because it didn't conform to the Constitution, and Parliament couldn't excuse itself from those legal requirements. Another important fact to emphasise here is that the decision of the High Court was respected. The Parliament didn't enforce its ban on the Communist Party after the High Court declared that it was unconstitutional. The Communist Party was allowed to continue on. All the branches of government accepted the ruling of the High Court and respected their decision that the legislation was contrary to the law. This also demonstrates a really fundamental commitment to the rule of law in a political or cultural sense. The branches of government conceded that they had to comply with the law as ascertained and enforced by the High Court. But we need to delve a little further and think back here to our differing conceptions of the rule of law. Given the nature of the Communist Party Dissolution Act, you might be guessing that the legislation was held invalid because it was fundamentally unfair or unjust or contrary to fundamental rights. After all, the legislation could be described as one that was contrary to freedom of speech, freedom of association. It was deliberately aimed to silence political opinion. But the legislation was not found to be invalid on this basis. The High Court found that, for the most part, the Federal Parliament was not required to act in a way that was compatible with fundamental rights. The law was found to be invalid on what we might call a technical, though that doesn't mean unimportant, basis, namely that it did not fall within the specifically enumerated legislative powers of the Commonwealth Parliament. We're going to talk a lot about what that means later in this course when we look at Parliament and its powers. The significant point to take away here is that though the Federal Parliament is subject to the law found in the Constitution, the limits on Parliament's power set out in that Constitution are relatively thin. They don't, for example, require Parliament to act conformably with human rights. So we might say that in Australia, government is subject to the law, but it's not legally required to do everything that some people might argue is essential to the rule of law. And in that sense, the rule of law remains a political ideal. Nonetheless, it's still a really useful concept to keep in mind throughout the rest of this course. You can use it to judge or assess certain legal principles and practices and think about whether you think it is compatible with the rule of law or whether it is going to diminish the rule of law within the legal system.